Fresh matter tomorrow.
What is the urgency?
My lord, the repatriation of the matters, my lord, the specific period of 3 years, my lord. Even though 3 years, my lord, they are repatriated, my lord. The urgency is interim order not granted in KSCT, my lord.
Huh?
Tomorrow.
Tuesday, what is the urgency?
Relieve ಮಾಡಿಬಿಡ್ತಾರೆ my lord ಅದಕ್ಕೆ.
ಏನಾಗುತ್ತೆ?
ಇಲ್ಲ
Tuesday.
tomorrow, my lord.
Tuesday. Nothing will happen. Relieve ಮಾಡಿದ್ರೆ we'll see.
Area number 12.
Yes, serial number?
So 12, my lord. This is in regarding your lordship may remember that the period of the panchayati, my lord, is already over. Whether still
Correct.
it can be continued. My lord, in my view, that's only based on the holding of office of profit, and that interpretation is required under the.
I know, but now it's of academic purpose.
Yes, my lord, my lord, even in the famous, my lord, the best judgment of Bommai's case, though period was over, still the Supreme Court held that wrong judgment cannot be continued or precedents.
No evidence.
Adana next week, that one day. Holding of a private, the contract in this case has been held as a holding of a office of profit.
Yes.
Days accommodation, your lordship will come.
Each time granted for necessary compliance, finally relist the matter on.
Grateful.
1 week. I prefer a week's time.
Yes,
I seek a week's time, my lord, to come.
each time granted for necessary compliance.
My lord,
The last occasion.
so for first case, my lord, respond number 6, I will file memo for dispensation. Lord, before the tribunal, my lord, the against the respondent,
My lords,
in connected.
in connected matter, my lords, 50% deposit has been permitted to withdraw, my lord. 25% deposit. Kindly directed to another 25% may be deposited and ಯಾಕಂದ್ರೆ ಒಂದರಲ್ಲಿ 50% ತುಂಬಿ 50% ವಿಡ್ರಾ ಮಾಡ್ಕೊಂಡಿದ್ದಾರೆ.
Appeal is on what ground?
My lord, here challenging liability. My lord, admittedly vehicle was goods vehicle. They are traveling, my lord, unauthorized passage. And so for that concern, my lord, we are collected extra premium. But in the policy, we are saying that, my lord, each person's 1 lakh, my lord, they have entered. That is limited liabilities.
If the accepted by argument of the learned council, my lords, then also, my lords, pay and recovery is coming.
That is also.
That's reason, my lords, I am
not
seeking-
arises here. My lord, the policy itself, it is clear, my lord, we are liable only 1 lakh.
The policy,
That is excess, my lord, that may be owner liable.
pay and recover. And the policy is issued by the insurance company's package policy, my lords.
5 cases are there, my lord, arising,
And-
both are arising same accident. Some cases, my lord, claimant not appeared. Some cases, my lord, owner not appeared. But after service of notice, my lord, in meanwhile, if it is, my lord, you are saying that 25%, that may be. But here, order is that, my lord, previous order, my lord, the claimants, my lord, permitted to withdraw 50% deposited amount with accrued interest should be their execution indemnity bond undertaking to redeposit the amount in withdraw with the applicable. That is order is there.
Right.
That may be same, my lord. If we are succeed, my lord, then recover.
In that case, my lords, 50% deposited. In our case, my lords, 25% is there.
Placing memo,
ಅದು ಇನ್ನೊಂದು 25% ಡೆಪಾಸಿಟ್.
notice to send to ಯಾರಿಗೆ? Dispense R6 notice R6 dispense first matter ಅಲ್ಲಿ. In other matters?
My lord, that is connected, my lord, serial number 4 and 5, my lord. That is.
One by one you tell us. Next ಅಲ್ಲಿ ಹೆಂಗೆ? Next ಅಲ್ಲಿ 3.1 ಅಲ್ಲಿ.
3.1 ಅಲ್ಲಿ ಸ್ವಾಮಿ respond number 5 already, my lord, Sanjay M. Joshi is appeared, my lord. The honorable court directed.
She counsel Shri Sanjay M. Joshi is directed to accept notice to respond number.
My lord, respond number that is already order.
Respond number 5 ಅಲ್ಲ already.
ಹೌದು ಆರ್ಡರ್ ಆಗಿದೆ ಸ್ವಾಮಿ, ಬೈ ಓವರ್ಸೆಟ್ ಮತ್ತ ಬಂದಿದೆ.
This is directed to show the limit then counsel Sanjay M. Joshi for respond number 4 instead respond number 5 ಅಲ್ವಾ? ಅದು ಬೇಡ. The week's time granted to take steps. Take steps to respond number 4.
Respond number 4 already appeared, my lord.
ಯಾರಿದ್ದಾರೆ?
ಬಸು ಜಲ್ದಿ ಅಂತಿದ್ದಾರೆ.
3
Connected appeared, my lord. BV Jalde is there.
3 ಗಿದ್ದಾರೆ.
R3, that is the same, my lord, owner.
4
Of owner, I will file memo for this.
ಅಲ್ಲ you want to dispense.
Yes,
memo ಹಾಕಿ.
please.
Same R4 ಗೆ placing memo on Reliance notice to R4 dispensed with the risk of counsel for the appellant. ಆಯ್ತಾ? Next. ಹೌದು dispense ಅದು R4 ಗೆ dispense. Next 3.2 ಹೇಳಿ. ಚೆಕ್ ಮಾಡಿ.
Same, my lord. That is also respond.
So R4 ಗೆ ಅಲ್ವಾ ಅದು ಕೂಡ? ಮೆಮೊ ಹಾಕಿ, ಅದು ಕೂಡ ಮೆಮೊ ಹಾಕಿ separate.
ಹಾಕ್ತೀನಿ.
Same order. 3.2 ಅಲ್ಲಿ. What about 3.3?
ಎಲ್ಲದರಲ್ಲೂ ಸೇಮ್ ಬಂದಿದೆ. I will file memo. I will file memo for dispensation.
ಯಾವ್ದಕ್ಕೆ?
Respond number, my lord.
1 and 2. 3.3 ಅಲ್ಲಿ
3.3 ಅಲ್ಲಿ 1 and 2 claimants are ಇದ್ದಾರೆ, ಅವ್ರಿಗೆ ಹೋಗ್ಬೇಕು ಸ್ವಾಮಿ ನೋಟಿಸ್.
ಆಯ್ತು. issue notice 1 and R3 ಗೆ
ಡಿಸ್ಪೆನ್ಸ್
served.
R3 served.
ಅಥಾರಿಟಿ ಇದೆ.
ಇವ್ರು ಬೇರೆ ಮ್ಯಾಟರ್ಸ್ ಅಲ್ಲಿ ಏನಾದ್ರು ಯಾರಾದ್ರೂ ಅಪಿಯರ್ ಆಗ್ತಾರಾ? R3 is it a party in any of the other matters?
ಹೌದು ಸ್ವಾಮಿ. BV Jalde is there. BV Jalde
is directed to accept notice for respond number 3 ಅಲ್ವಾ?
ಹೌದು ಸ್ವಾಮಿ.
R3 ಅಷ್ಟೇನಾ ಇದರಲ್ಲಿ? 1 2 3
ಹೌದು ಸ್ವಾಮಿ, ಅವರಲ್ಲಿ ಪಾರ್ಟಿ ಮಾಡಿಲ್ಲ ಅದರ.
ನೆಕ್ಸ್ಟ್ 3.4 ಗೆ ಬನ್ನಿ.
3.4 ಅಲ್ಲಿ ಸೇಮ್ ಕ್ಲೈಮೆಂಟ್ಸ್ ಗೆ ನೋಟಿಸ್ ಹೋಗ್ಬೇಕು.
ಒಂದು ನಿಮಿಷ. R4 ಇದರಲ್ಲಿ R4 ಅಲ್ವಾ? ಮ್ಯಾನೇಜಿಂಗ್ ಡೈರೆಕ್ಟರ್. ಇದರಲ್ಲಿ ಶ್ರೀ ಜಲಡೆ directed to accept notice to respond number 4.
Please.
Next R1 and R2 ಆಗಿದೆ.
Weeks time.
Issue notice to respond number
1 2 3.
1 2 and 3. Next. IA ಯಾವ್ದ್ರಲ್ಲಿ ಹಾಕಿದ್ದೀಗ? ಎಲ್ಲದರಲ್ಲಿ ಹಾಕಿದ್ರಿ IA?
IA ಹಾಕಿಲ್ಲ,
ಮೆಮೊ ಹಾಕಿದೀವಿ ಸ್ವಾಮಿ. ಮೆಮೊ ಫಾರ್ $1.
Memo for
1 2 3 ಅಲ್ಲಿ.
That is office of
1.1 ಇದು 3.3 3.1 3.2.
accepting the reason stated in the memo ಅಂತ. Memo the
25%
are permitted to withdraw.
25% ಮಾಡಿದಾರೆ. ಡೆಪಾಸಿಟೆಡ್ ಅಮೌಂಟ್ 25,000.
ಅದೇ 25% ಅದನ್ನು full ಕೊಡ್ತೀವಿ. Full 25%.
Kindly directed to another 25%.
Deposited amount with the accrued interest, subject to their execution of indemnity bond.
ಆಯ್ತು ಸ್ವಾಮಿ, ಅದೇನವ
To same, to redeposit the amount, so withdraw
ಆಯ್ತು
with the applicable bank of rate interest in the event the claimant suffer an adverse order.
ಆಯ್ತು.
No, the records ಬರ್ಬೇಕಾ?
Please.
Records ಬೇಕಾ?
Meanwhile records may be called.
ಅಲ್ಲ ನಾನು ಅಮೌಂಟ್ ತಕೊಂಡ ನಂತರ ಡೆಪಾಸಿಟ್. ಯಾಕಂದ್ರೆ ಅದು ಇಲ್ಲಿ ಬಂತ ಮತ್ತೆ ನಾನು ಅಮೌಂಟ್ ತಗೊಳಕ.
That order may be concerned serial number 3, 3.1, 3.2. 3 cases. Other 2 cases already ordered. That was all.
3 ಇದು 3 ಈಗ ಈ withdraw ಮಾಡಿದಿರಲ್ಲ 3 3.1
3.2
and 3.2 ಅಲ್ಲಿ.
Please.
3.3 and 4 ಅಲ್ಲಿ ಇಲ್ಲ.
ಆಗಿದೆ, ಆಲ್ರೆಡಿ ಆರ್ಡರ್ ಆಗಿದೆ.
ಒಂದು 3 ಮಾತ್ರ 3 and 4 ಅಲ್ಲಿ ಬೇಡ ಅಲ್ಲ 50 25%.
ಅಲ್ಲ 25 ಎಂಟೈರ್ ಅಮೌಂಟ್
25% ಡೆಪೋಸಿಟ್ ಅಮೌಂಟ್ ಇನ್ ಡೆಪಾಸಿಟ್ ಅಂತ ಹಾಕಿ
amount in
25% ಅಂತ ಹಾಕ್ಬೇಡಿ ಅಮೌಂಟ್
ಮತ್ತೆ ಆಮೇಲೆ 25 ಕೊಡ್ಬಾರ್ದು.
ಅಮೌಂಟ್ ಇನ್ ಏನದು ಏನ್ ಮಾಡಿದಾರೆ ಅದೇನಿಲ್ಲ ಬೇರೆ ಏನು ರೆಕಾರ್ಡ್ಸ್ ಈಗ ಬೇಡ ನೋಡು ಅವ್ರು ಮಾಡಿ
ಹೌದು.
Please.
Next time, ಈ batch matters ಇರುತ್ತಲ್ಲ, what lawyers easy, you just make a note and give it up. ಒಂದೇ ನಿಮಿಷದಲ್ಲಿ ಆಗುತ್ತೆ.
House.
Next. Pass over. Office to put up report regarding notice issued to R1, R4 to R7.
In this matter, I am appearing for appellant my lordship. During the course of day, I filed memo of appearance. The legal service authorities entrusted me case to me.
For respondent ಈಗ
Appellant. Now he Sheshadri is the now become the SGP once.
serial number 6 ಅಲ್ವಾ ಶೇಷಾದ್ರಿ
AGM. Sri Sheshadri become the AGM my lordship. That's why legal service authority has entrusted me case to me.
is permitted to file our
During the course of day, I filed.
memo of appearance for the appellant. Office is and office is directed to show the name of she so and so and the so and so. Instead, she Sheshadri Jason for the appellant. But 2 weeks time granted to file objection if any by the learned additional SP for IA number 2 of 2024.
Objections will have to be filed by. I filed an application for suspension of sentence.
Rape and murder.
Yes.
If you want your order, we will pass, or else we withdraw the decision for the time being. This we are going to reject this one application.
2 weeks.
2 weeks. Yeah, okay, 2 weeks. Withdraw the time being, yes. Or else we'll dismiss.
Yes.
Yes.
To renew my prayer after some time. my lords.
For the appellate.
With liberty to renew my prayer after some time.
Memo to withdraw the memo by not pressing IA number 1 of 2025 for the time being. For the time, permission accorded. Permission accorded, yes. This is the matter for final hearing.
My lord, serial number 8. I appear for the appellant, my lord.
Heard admit, registry is directed to secure the TC. It's a brutal rape and murder.
No, 8.
My lord, serial number 8, my lord.
Yes.
My lord, serial number 8, my lord, I appear for the appellant in the matter. My lord, I am the respondent number 14 in the writ petition, my lord. I'm a factory owner. My lord, the writ petition was filed by the Association of Sugarcane Growers, challenging the notification of the sugar commissioner, my lord, whereby the price of the sugarcane was reduced from 2,500 to 2,200. Now, my lord, the writ petition was allowed with direction to the government to recover the amount from the factory owners, my lord. My lord, the appellant herein, my lord, had undergone CIRP, my lord, under the IBC. In 2021 itself, the CIRP was initiated and it has been accepted by the NCLT, my lord. Now a new management has come on board. During this period, my lord, the appellant was could not contest the writ petition. And however, my lord, in terms of the order of the NCLT, all the previous liabilities of the company are absolved. That apart, my lord, in connected writ appeals, my lord, the order of the single judge has been stayed, my lord. If I may ask my friend to pass the. Uh,
What is the ground? What is-
my
what is
lord,
the interim
my lord,
order? Ah,
my lord, the appellant herein has undergone CIRP, my lord. A new management has come into place. My lord, in terms of the order of the NCLT, all previous liability is extinguished, my lord. Now, my lord, the sugarcane commissioner is threatening to recover the amount from this management, my lord, the present management.
The resolution plan,
Yes, my lord.
there is no provision for this, for these dues.
No, my lord. If I may, my lord, I have filed IA for additional documents. Page number 1662, my lord, of the IA.
Copy. Volume,
My lord, it's IA for production of additional
Volume
documents.
3. That's it.
Volume.
Volume.
so this amount is owed to whom?
My lord, in terms of the order, we have to pay to the farmers, my lord, the sugarcane growers.
So then who cries for the baby? Nobody cries.
My lord, if I may draw your lordship's attention to page number 1662, my lord, of the
The
NCLT order.
Government is least interested. Who will cry for the farmers? Nobody cries.
My lord, the order is at page number 1662, my lord.
Yes.
My lord, para number 6, my lord, of the order. In terms of the judgment of the Honorable Supreme Court in the matter of Ghanshyam Mishra and Sons Private Limited, on the date of approval of the resolution plan by the adjudicating authority, all such claims which are not part of the resolution plan shall stand extinguished, and no person shall be entitled to initiate or continue any proceedings in respect to a claim which is not part of the resolution plan.
What happened? There were some other judgments, no? Some rainbow, what is the other developments?
My lord, sir.
No, they have to they have to challenge it. If at all they want their rights
Yes,
also to be considered, they have to challenge it.
yes,
Now, where is that order? Where is that? This is the order, is it?
yes, my lord. This is the order. This is the order, my lord, of the NCLT.
Noodle, servant, government servant.
Now, this order was passed on.
My lord, in 2022, my lord, I'm 18/10/2022, my lord.
18/10/22.
2020. Yes, my lord.
So, as on such date, all your liabilities disappear into thin air.
Yes, my lord. Yes,
That's
my lord. By the operation of law and also the judgment of the Supreme Court.
That's a equitable argument.
Yes.
So, so
My lord.
after, Arjuna, just in lighter vein, I'm reminding.
Yes, yes.
So after 1810-22,
Yes,
after the
ma'am.
resolution plan, it has come under control of the new management.
Yes, my lord.
So after 22, at least, now when was this order passed? Now let us have a look at the order passed. Now you take us to the order of the Kane Commissioner.
Kane Commission of the single judge, my lord.
No, now, correct. Now,
Yeah.
the order of the single judge is upholding the order of the Kane Commissioner, isn't it?
No, my lord. The order of the single judge is
Ah.
to quash the notification whereby the notification of the Kane Commissioner reducing the price from 2,500 to 2,200, my lord. The price was reduced from 2,500 to 2,200 per metric ton. That was challenged by the Sugar Cane Growers Association. And in terms of the direction of the court, my lord,
Now,
which is that.
correct. So now it stands at 2,500.
Yes, my lord. And if I may take your lordships to page number 72 of the writ appeal, my lord, where is the order, internal page number 52 of the judgment.
Page?
72, my lord, of the writ appeal.
Correct. So the subject matter of the writ proceedings was an order with respect to which period?
Prior to it is the notification, my lord, is of the year 2015, whereby retrospectively the price was reduced. Notification is of the date 29/8/2015.
Page?
My lord, it is
71 in the operative portion.
in the operative portion. 71, my lord. In the operative portion, it is mentioned. Impugned order dated 29/8/2015, passed by the respondent number 2.
No, just tell me.
Yes, my lord.
Now the debt came to be crystallized only by the order passed in 24. So where does your liability disappear? As on the date of the resolution plan.
Yes, my lord.
Whatever liabilities were crystallized.
Yes, my lord.
Were a part of the resolution process and the plan made.
Yes, sir.
Now this was not a debt as on that date. This is a debt that came to be crystallized in the year 2024.
Yes,
After
my
the
lord.
new management has come into play. So how
Yes,
does
my.
it wipe out the liability now?
My lord, but it is for the acts or the procurement that happened between those periods, my lord, before after 2015, and payments were made then.
Now I'll have it next week. You apply your mind to it, and then you
Yes, ma'am.
demonstrate. Let us see.
Yes, ma'am.
Uh,
A date
now
may
what-
be fixed.
Now the only simple point is that the resolution plan
Yes, ma'am.
will wipe out debts that are crystallized. So you
Yes,
take
ma'am.
us on by the next date you
My lord,
apply.
if I may submit, my lord, one point. My
Yeah.
lord, my contention would be in addition to the contention raised by the factory owners in the other writ appeal, my lord.
No, that we'll see. We'll have all
Yes.
the matter.
Yes.
But let us see. First, you demonstrate how whether it was a liability as on the date of the resolution plan being accepted.
Yes, ma'am.
Under terms of the IBC code, you just point out. So let us see whether it's a corporate debtor, etc., etc. You take
Yes.
us through it. Let us see
Yes.
what
Yes.
relist the matter. We'll have it on 11th.
Yes, ma'am.
Let us see. You just convince on that one point.
Yes, ma'am. Great.
Yes.
My lords, and may I please report.
Notice,
There's a delay of 45 days, my lords.
additional SPP is directed to accept notice.
Humble submission, my lord.
Respondent. Delay ಮಾಡುದಾ ಕಂಡೋನ್ ಮಾಡ್ಬೋದಾ?
My lord, humble submission, my lord. Complainant and surviving victim are present before the honorable court, and they want to get implemented in the appeal as respond number 2 and 3, my lord. In
Notice
the light
ಆಗಿದೆ?
of Lakhimpur
Then
Kiri.
issue
Alas,
ಯಾರ್ದು?
today it has come for the first time.
Party ಮಾಡಿಲ್ಲ ನೀವು?
My lords,
Arrange
I have
must
not paid the party. Now that they are filing an implementing application, I'll change the cost title.
You have to ಎರೆದ as a party ಅಲ್ವಾ?
Yes, yes. ಅಲ್ಲಲ್ಲ, ಇದು criminal appeal.
ಹೌದು. ಹೋಗ್ಸೋ ಇದೆಯಾ?
ಹೋಗ್ಸೋ ಇಲ್ಲ.
My lord, in the light of Lakhimpur violence
Then you have
case.
to file
Yes,
application.
my
Let's
lord. Yes, yes.
say
They are
have to
just
file an
seeking
application.
time to file.
This is after 2 weeks for delay. What
Delay.
is the offense?
My lords, offense is 302 minutes. 302, 307, 326, 428, read with 25(1)(a) of Arms Act. Arms Act. No special case of SCST nor POCSO.
Re-notify, ಹಂಗಾದ್ರೆ ಹೆಂಗೆ ಡೇಟ್ 11, 10, date 3notify on 13/2. In the meantime, the council learned additional SPP is permitted to file objection if any.
The delay may be condoned minutes. Aye. There is 45 days delay.
On dilemma. Yes, they put in. Order on IA 1 of 25, accepting the reason assigned in the affidavit.
Affidavit minutes.
Affidavit accompanied to IA number 1 of 2025. So also considering the fact that the appellate is in judicial custody
Custody.
from the date of
Arrest.
judgment, date of the impugned judgment, the delay of
45 days.
43 days in filing IA 1 of 25, filing this appeal is condoned. Accordingly, IA 1 of 25 is disposed.
Great films. Date of his
Of
arrest.
his arrest itself, date of his arrest. Right.
Valentines.
Password.
Lordship, they have filed the original register. I want to have a glance. What any date may kindly given, I may be kindly permitted to peruse the original record.
The respondents are permitted to inspect the register,
Please,
relist the matter on.
any day
Date.
other than Wednesday. Right.
Please.
Public.
The respondent is permitted to inspect the original register. Order to detective safe custody. Relist the matter on 14.
Please.
order. Criminal appeal number 2001102 of 2018, filed by the appellant / accused, is dismissed, being divide of merits. Consequently, the judgment of conviction and order of sentence dated 27/4/2018 passed in session case number 71 of 2016 by the principal district and session judge at Raichur is affirmed. Though the learned counsel Shri Sambulinga S. Salimat was appointed as the counsel by the legal service authority, he expressed his inability to present before this court today. As such, we appointed today beda, last date of hearing, madam. On the date it was posted for hearing. As such, we appointed Shri Dastagir Saab B. Nadaf as amicus curiae to render his assistance to this case. In this case, accordingly, the legal service is hereby directed to pay a retainer fee of rupees 25,000 to Shri Dastagir Saab B. Nadaf.
Macho.
So Nadaf has become High Court lawyer. ಇರ್ಲಿ ಸ್ವಲ್ಪ ಅದೇನಾಗುತ್ತೆ ಸ್ವಲ್ಪ ಪುಷ್ ಮಾಡಿದಾಗ ಫಸ್ಟ್ ಟೈಮ್ಗೂ ಸೆಕೆಂಡ್ ಟೈಮ್ಗೂ
Yes, definitely.
ಬಟ್ ಇನ್ನೂ ಸ್ವಲ್ಪ ಕಷ್ಟಪಟ್ಟು ಓದ್ಬೇಕು. ಹೈಕೋರ್ಟ್ ಲಾಯರ್ ಆದ ತಕ್ಷಣ ಓದೋದ್ ನಿಲ್ಸ್ಬಾರ್ದು. No, I tell you, there was one international conference.
Yes.
It was a course, 2 weeks course in Budapest, Hungary.
Yes.
On public interest lawyering. So we had the students, I had gone and from China, South Africa, etc. African nation, they speak perfect English.
Yes.
Commonwealth, everybody. Chinese were struggling then.
Oh.
This may have been about 20 years back. But if they speak 5 words, communication is so strong that you know what they are speaking. So this hesitancy that I don't know English. So the Chinese, without knowing English,
Yes.
used to communicate perfectly because they know less language.
Yes.
The communication is to the point.
Yes.
Those who know English will go to Shakespeare, etc., and talk more.
Yes.
If you don't know, actually, you can communicate crisply.
Exactly.
So, positive. Yes. Yes. Phone ಮಾಡಿ.
Amit Nanda. Yes, yes.
My brother was saying,
My lord.
those with trial exposure are best suitable for arguing appeals
That is true.
rather than those only doing
Exactly.
appeals,
Yes, yes,
which is absolutely correct in criminal matter.
yes.
Practical experience is very much
Practical,
required.
yes.
Criminal appeal. as
That
per
they are the
conduct-
persons who creates the story and the defense, my lords. That is the main thing. And to be fair enough before my lords, even I have conducted so many trials, my lords, but I have been learnt a lot, my lords. This is also, my lords. This is also MC Brother judgment.
Where is Mamadpur, Rajesh? Mamadpur. 6.
24, serial number 24. Sorry, next protocol 6.
Who is for respondent? SPP in this state appeal?
Santosh Patil, sir.
Santosh Patil.
Yes, ma'am. Girish, son of Shakti.
Mamadpur Bandhu. Yes.
Sir. Your lordship, my lord, directed me to ascertain whether the intimation was issued within 21 days. My lord, it is issued, my lord. They have sent immediately. In the approval order of the government itself, Annexure F, there is a reference. The Annexure F to the writ petition speaks. And also I am filing.
Within time, huh?
Yes, ma'am. Endorsement allu ಅವ್ರಿಗೆ ಕೊಟ್ಟಿರೋ endorsement ಅಲ್ಲಿ the petitioner, the wife of the detaining ಏನು endorsement ಕೊಟ್ಟಿದ್ದಾರಲ್ಲ ಅದರಲ್ಲೂ ಬಂದಿದೆ. All the references. One to 7 references, my lord, in Annexure F. They are all, my lord, stated in the endorsement. ಸರ್ಕಾರದ ಆದೇಶ ಸಂಖ್ಯೆ ದಿನಾಂಕ 25/9/24. That means, my lord, it was received to the government and the body within 21 days.
This is only, reference is only with regard to submission of the representation by the detainee. It is not Lord's reference with regard to placing the representation before the advisory board within 21 days.
Now I have produced, my lord, documents. Page number 2. The proceedings, my lord, the government approval. ಉಲ್ಲೇಖ ನಂಬರ್ 2, ಉಲ್ಲೇಖ 1, 2, 3. These are the, my lord, dates of the letters of the deputy commissioner, 22/9/24, 23/9/24.
After invoking,
My lord.
this is the government order.
Yes, my lord.
Subsequently, confirmation order.
Yes, my lord.
Confirmation. order.
Yes, my lord.
So when you place it before the advisory board?
My lord, I have asked the instructions, my lord, inward ಅದು ಏನಾದ್ರು ಮುಟ್ಟಿದವ್ರು ಕೊಡಲ್ಲ. ಹೋಮ್ ಡಿಪಾರ್ಟ್ಮೆಂಟ್ ನಲ್ಲಿ ಕಾನ್ಫಿಡೆನ್ಷಿಯಲ್ ಇರುತ್ತೆ, ಕೊಡಲ್ಲ ಅಂತ
ಡಿಲೇ ಅಲ್ಲಿ ಆಗಿದೆ ಅಂತ.
ಆದ್ರೆ ಇದು ಸ್ವಾಮಿ ಈ ರೆಫರೆನ್ಸ್ ಅಲ್ಲಿ ಡೇಟ್ಗಳು ನೋಡಿದ್ರೆ the detention order, my lord, is a
So
My lord.
according to you, there is a delay caused due to some administrative, exigent.
reasons. ಇಲ್ಲ ಡಿಲೇ ಆಗಿಲ್ಲ ಅಂತ ಹೇಳ್ತಾರೆ. We have submitted within, my lord, 21
The
days.
advisory board,
ಹೌದು.
ಎಲ್ಲಿದೆ ಇದು? When you.
That is what I asked, my lord. They have shown this, my lord, the proceedings of the government wherein all these letters were referred.
Let us see. Now you tell us what are the grounds.
Yes. Lords, I have given a short synopsis, Lords, indicating the
Tell us.
I have given synopsis, Lords, stating chronologically the date of events, Lords.
You take us to your best ground.
Lord's best ground is Lord's. I will urge only three grounds, Lords, not more
Correct.
than.
So what according to you is the best ground you start?
First ground is not placing the detinue's representation before the advisory board within 21 days. As per,
Which section?
as per section 10. Neither in their statement of objections nor in the documents produced today before this honorable court. Yes.
Yes, now Mamadapur, you
Yes.
narrate the facts.
Yes.
You are assailed the order, detention order dated.
Detention order dated, my lords,
21/9.
21/9/2024.
20,
1/9/2024.
Hmm.
Filed annexure B,
passed
And
by,
passed by the second respondent, district magistrate.
second respondent.
Yes, my lords.
Second respondent.
Yes, and
Second respondent. That is it. Who is that authority?
district magistrate detaining other.
District magistrate, yes.
Then the order at annexure H5,
By order number ಹೇಳ್ಬಿಡಿ.
order number, my lords,
Bearing
RB,
number,
RB/MAG/Gunda Act
dash Gunda Act,
/CR-98/2023-24.
2023-24.
Yes, this is preliminary order of detention.
Yes. Next now,
And yes,
subsequent confirmation order,
5/11/2024.
5
11,
and 2024.
yes,
Bearing number,
HD 508
hmm,
SST
hmm,
2024.
04.
Yes,
Annexure?
annexure H,
Annexure.
passed
Yeah.
by the
Passed by
first respondent.
first respondent.
Yes,
Yes. Now, who is the petitioner?
petitioner is the wife of detenue Madiwalaya Hiremat.
Detenue.
Yes,
Hmm. So what is the ground of for this one for invoking? Is there good any specific this one is there?
yes,
Repeated
notes.
act anta. Only it's a repeated act.
Repeated act notes. He is involved in 8 cases.
8 cases.
Yes, details of which have been given at
Yes,
page,
yes. 8 cases. Details ಇಲ್ಲಿ ಕೊಟ್ಟಿದ್ದಾರೆ.
Page number
page number
31.
21.
31.
21. Non-petition of 20.
Number 31 in your petition alva.
21 notes. It's
21.
21 ಅಲ್ಲೇ ಇದೆ.
ಹಾ.
31 is notes translated copy of notes English and ಕನ್ನಡ ಎರಡೂ ತರಲ್ಲೂ ಕೊಟ್ಟಿದ್ದಾರೆ.
Just tell us,
Yes,
when the respondent police opened rowdy sheet, rowdy sheet ಇದೆಯಾ?
rowdy sheet is opened notes.
Hmm.
It is opened.
Hmm.
I shall just. It is on. ಕೇಂದ್ರ ಸಿಬ್ಬಂದಿ. Rowdy sheet date lots how to, I will furnish lots, but he is a rowdy sheet.
So anyhow rowdy, rowdy sheet is opened.
Yes, yes,
Rowdy sheet is opened.
yes.
Hmm. ಅದು ಎಲ್ಲಿ
Before.
Even prior to lots this thing, his name is included in the list of rowdy sheeters.
just show us ಅದು ಯಾವುದಂತ ಎಲ್ಲಿ ಅಂತ ಮತ್ತೆ ನೋಡಿ ಹೇಳಿ.
Yes,
ಯಾವ police station ಎಲ್ಲಿ open ಮಾಡಿದ್ದಾರೆ ಅಂತ.
yes, yes, I shall.
Carrying number ಕೂಡ ಅದೊಂದು ಹೇಳ್ಬೇಕು.
ಹೇಳ್ತೀನಿ sir.
Yes. So thereafter this order passes.
Yes,
This order passes.
yes, my lord.
Now when the order was communicated,
Communicated on 21/9, he was in custody, my lords, at the time of passing of this order. In crime number 70 of
wait a minute, he was in custody,
yes,
in crime number
70 of 2020-24 of APMC Police Station, Vijaypur.
70 of 2024
Yes,
of AP.
APMC Police Station, Vijaypur.
Only in this case, no other cases
No.
were pending.
No.
No.
The cases were pending,
Pending.
but he was
Was on
on
bail.
bail in all cases.
In all the
Yes,
cases. Now, when this order was communicated, so he was in custody.
custody,
When the order was communicated,
21/9/24 itself, this order was communicated.
so same day,
Same day.
so 21/9 itself communicated.
Yes, ma'am.
The rowdy sheet was opened on 26/12/2020.
20,
26/12/2020. It is at page number 44, third para.
page 44. only. Okay. So communicated, when the representation, detainee submitted the representation,
Detinue submitted representation, lords,
On 28/9,
28/9.
wife submitted.
ಇಲ್ಲ.
ಅಲ್ಲ detainee
ಇಬ್ರು-
ಒಂದು ಜೈಲಿಂದ ಒಂದು ಕಳಿಸ್ತಾರೆ through.
Wife also submitted,
Wife-
detinue also submitted, both representations were rejected notes.
ಅಲ್ಲ ಯಾವ ಡೇಟ್ ಯಾವ?
Yes, I shall. I have not stated.
It is also, my lord, on 28/9/24.
That is also Mohammadpur, that is also one of the ground.
Yes,
Can that ground also, when any delay in considering the representation,
ಇಬ್ರು ಅದೇ ದಿವಸ ಸ್ವಾಮಿ,
ಯಾವಾಗ?
28/9/24,
ಇಲ್ಲ, ಇಲ್ಲ.
28/9/2024.
It is, my lord, in ವಿಷಯದಲ್ಲಿ, in annexure F, subject ಅಲ್ಲಿ wife ರೆಫರೆನ್ಸ್ ಇದೆ, ಉಲ್ಲೇಖ ನಂಬರ್ 6ರಲ್ಲಿ ನಿಮ್ಮ ಮನವಿ ಅಂತ ಹೇಳಿ ಈ ಕೆಳಗಡೆ ಟಿಕ್ ಮಾಡಿದ್ದಾರೆ, that is the detinue ಮಡಿವಾಳಯ್ಯ.
So same
Yes,
communication.
ma'am. Yes,
That is the same.
28.
28/9/2024,
Yes.
before to the commissioner.
ಹೌದು.
ಹೌದು.
Respondent ಯಾರು? To the
To the lords, respondent number 1 through prison.
respond number 1 through
ಹೌದು.
prison.
It was
ಬೆಳಗಾವಿ ಮುಖ್ಯ ಅಧೀಕ್ಷಕರ ಮೂಲಕ.
ಹಾ.
ರೆಫರೆನ್ಸ್ ನಂಬರ್ 3.
ಅಲ್ಲ, one small correction.
it was rejected prior to it going to the advisory board itself. Or when matter was pending there, it was rejected.
No, no, no. Even prior to going before the board,
It was
this
rejected.
representation was rejected. Annexure E. Lords, one
It's
small
communicated ಯಾವಾಗ? When the representation communicated.
yes, one small correction before that. Representation submitted by the detinue is on 25/9/2024, not 28/9.
25/9,
Yes, my lord.
when the representation communicated,
Lords, it was rejected wide,
communicated ಯಾವಾಗ? Rejected ಯಾವಾಗ?
communicated, lords, ಇದರಲ್ಲಿ date ಹಾಕಿಲ್ಲ, but 39 is the order rejecting the my representation.
39/2014,
Annexure E.
so communicated and rejected,
Yes,
same day.
not same day, my lords.
ಆಯ್ತು.
25/9 representation submitted. When it was sent to lords, the department is not, but it was rejected on 39/2024. That is on the 5th day.
So it's rejected 39.
Yes.
By the authority, by respond number
1.
1 or respond number 1. So in the meantime, state confirmed,
State confirmed,
Approved.
lords, on 5/11. Annexure H, page number 51.
on 5/11.
Yes,
ಎಷ್ಟು?
51 lords, Annexure H.
ಹಾ. ಈ time ಅಲ್ಲಿ ಬರ್ಬೋದು, but confirmation So when this one, your representative, the detainee produced before the advisory board, and when the advisory board confirmed?
Yes, my lords. That is on, lords, I have produced along with my writ petition. He was on.
Date, everybody, date.
Yes, yes. Date.
After 5/11 or before 5/11?
Before 5/11 he was.
Before 5/11.
5/11 he was produced before the advisory board.
Right. So confirmation.
He was produced.
Advice, where is your file? Original file.
Original file.
Advisory committee's proceedings,
My lord.
you can place it before us for our perusal, though we may not keep it open for inspection.
I asked my lord, then home department ಕೇಳಿದ್ವಿ confidential
No, no.
ಕೊಡಲ್ಲ ಅಂತ. Yeah, I can, may request your lordship, my lord, there is a directions, my lord, I will get the file, entire file.
All the
get the-
habeas corpus, Gunda Act cases, this is state government, they'll place, and they have to place the original record, entire file.
Advisory
For
board.
our perusal, yes, yes. So date wise, there will be.
ಹೌದು,
date
ಅದು
wise
ಇರುತ್ತೆ. Grounds
ಇರುತ್ತೆ.
ಬರೀ,
ಯಾವಾಗ
yes,
produce
yes, my lord.
ಮಾಡಿದ್ರು, even including advisory board report.
Opinion.
ಇರುತ್ತೆ ಅದು.
ಹೌದು ಸ್ವಾಮಿ.
Annexure G ತಾವು ನೋಡಿದ್ರೆ page number
Annexure
49.
G is the date fixed for my lord. On
No,
24/10,
not that, with my petition.
petition page number 49.
This detainee, he was produced before the advisory board on 24/10/2020.
24.
Advisory board ಅಲ್ಲಿ ಸರ್ ಇದ್ದಾರೆ.
ಹೌದು,
ಇದ್ರ? ಅಲ್ಲ, ಇದ್ರಲ್ಲಿ ಏನಾದ್ರು ಇದ್ರಾ?
ಇದ್ರಲ್ಲಿ ಇಲ್ಲ. ಇದರಲ್ಲಿ ಸಾಹೇಬ್ರಿಲ್ಲ.
ಇಲ್ಲ ಸಾಹೇಬ್ರಿಲ್ಲ.
ಇಲ್ಲ. ಸೋಮಶೇಖರ್
ಬೇರೆ ಮಗ್ದುಮ್ ಸಾಹೇಬ್ರು, ಯರೂರ್ ಸಾಹೇಬ್ರು, ಮಗ್ದುಮ್ ಸಾಹೇಬ್ರು, ಸೋಮಶೇಖರ್ ಸಾಹೇಬ್ರು ಇದ್ದಾರೆ.
Yes. So this is on 24/10 ಗೆ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದ್ದಾರೆ.
ಹೌದು.
ನೋಟಿಸ್ ಅದು ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದ್ದಾರೆ.
So 21/9/2024 ಅಲ್ವಾ ಡಿಟೆನ್ಷನ್
ಹೌದು.
ಆರ್ಡರ್? 24/10 ಗೆ.
Yes.
ಶುರುವಾರ 5 ಗಂಟೆಗೆ.
Yes. Yes.
Lords,
Yes, yes. Now 24/10 ಅಂತ ಹೇಳಿದ್ರೆ
ಹೌದು.
after 21. So
more
21
than 1 month, 3 days, almost 34 days, lords, after detention.
He produced on the 24/10, my lord, but the papers were placed before 21 days.
what is
Section 10 ಪ್ರಕಾರ.
Section 10.
Section.
Every case where a detention. That order has to be placed,
Yes.
accused.
Yes. Now,
Order
Papers.
yes, lords, order has to be placed. Now, lords, neither the statement of objections nor the documents produced before this honorable court today indicate that there is any material to indicate that this order of detention was or grounds of detention were placed before the advisory board with
Whether the initial order of detention has been placed before the advisory board or not.
no.
In
That is the
terms,
only
in
question.
terms of
Yeah,
section 10.
My lord,
One
annexure
part
H, annexure H, first ಪ್ಯಾರಾದಲ್ಲಿದೆ. May I read, my lord?
Yes, yes.
ಜಿಲ್ಲಾಧಿಕಾರಿ ಹಾಗೂ ಜಿಲ್ಲಾ ದಂಡಾಧಿಕಾರಿ ವಿಜಯಪುರ ಜಿಲ್ಲೆಯವರು ಕರ್ನಾಟಕ ಕಳ್ಳಬಟ್ಟಿ ಸ್ವಯಂಸೋ ಅಧಿನಿಯಮ ಉಪ ಪ್ರಕರಣದಡಿ ಮಡಿವಾಳಯ್ಯ ಬಿನ್ ಪಂಚಾಯತ್ ಹಿರೇಮಠ್ 35 ವರ್ಷ ಸಾಕಿನ್ ಸ್ವಯಂಸೋ ಹಾಲಿ ಕೇಂದ್ರ ಕಾರಾಗೃಹ ಬೆಳಗಾವಿ ಬಂಧನ ಇವರ ವಿರುದ್ಧ ಬಂಧನದ ಆಜ್ಞೆ ಸ್ವಯಂಸೋ 21/9/24ರಲ್ಲಿ ಹೊರಡಿಸಿರುವ ಬಂಧನದ ಆದೇಶವನ್ನು ಸದರಿ ಅಧಿನಿಯಮದ 3ನೇ ಪ್ರಕರಣದ 3ನೇ ಉಪ ಪ್ರಕರಣದ ಅನ್ವಯ ಸರ್ಕಾರವು ಆದೇಶ ಸಂಖ್ಯೆ ಸ್ವಯಂಸೋರಲ್ಲಿ ಅನುಮೋದಿಸಿದ್ದು. After placing before the government only, they have approved. That is the date of 25/9/2024.
Section 10.
ಸದರಿ ಅಧಿನಿಯಮ 9ನೇ ಪ್ರಕರಣದಲ್ಲಿ ರಚಿತವಾದ ಸಲಹಾ ಮಂಡಳಿಯು ಬಂದಿಯನ್ನು ಬಂಧನದಲ್ಲಿಡಲು ಸಾಕಷ್ಟು ಕಾರಣಗಳಿವೆ ಎಂದು ದಿನಾಂಕ 29/10/24 ವರದಿಯಲ್ಲಿ ಅಭಿಪ್ರಾಯಪಟ್ಟಿದೆ. That is after my lord producing the detainee before the advisory board.
There are two things under section 10.
My lord.
Once you pass a provisional order.
Yes.
Within 3 weeks, you must place it before the committee. Then the committee will give a hearing to
Yes, my
the
lord.
detainee and then give its opinion, after which you do the confirmation. One of the contention which you will have to check is that this detention order must be placed before the advisory committee of the High Court with due acknowledgement within 3 weeks from the date of the detention.
21/9. Yes.
That you will have to check. So High Court
But-
ಅಲ್ಲಿ High Court advisory committee ಒಂದು
ಹೌದು
signature ತಗೊಂಡು.
ಹೌದು ಸ್ವಾಮಿ.
that you will have to.
ನೋಟ್ ಶೀಟ್ ಅಲ್ಲಿ ಬರೆದಿರ್ತಾರೆ.
So if the advisory committee proceedings are there, in that everything will be there.
With due respect, may I request my lord for.
Just 29/10/2024 ವರದಿಯಲ್ಲಿ ಅಭಿಪ್ರಾಯ ಪಟ್ಟಿರುವುದು.
ಹೌದು ಅಂದ್ರೆ
ಇದು
ಅಡ್ವೈಸರಿ
subsequent
ಬೋರ್ಡ್
ವರದಿ
ವರದಿ ಆಮೇಲೆ ಕೊಟ್ಟು ಆಮೇಲೆ 5/11 ಆರ್ಡರ್ ಮಾಡಿದ್ದಾರೆ ಸ್ವಾಮಿ.
ಅಡ್ವೈಸರಿ ಬೋರ್ಡ್ ಮುಂದೆ ಪ್ಲೇಸ್ ಮಾಡಿದ್ದೀರಿ ಅಂತ ಎಲ್ಲಿದೆ? 25
ಇಲ್ಲ,
ಅದರ ಮೊದಲು.
ಅಡ್ವೈಸರಿ ಬೋರ್ಡ್ ಎದುರಿಗೆ ಪೇಪರ್ಸ್ ಪ್ಲೇಸ್ ಮಾಡಿದ್ದಾರೆ.
You just come to G, annexure G. Annexure G says 24/10/2024 ರಂದು 5 ಗಂಟೆಗೆ ಜಡ್ಜ್ ಟಿ
ಅಂದ್ರೆ ಡೆಟಿನ್ಯೂ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಕ್ಕೆ ಈ ಡೇಟು.
ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡುವಾಗಲೆಲ್ಲ ಇದನ್ನು ಪ್ಲೇಸ್ ಮಾಡಿದ್ದು, ಅದರ ಮೊದಲೇ ನೀವು ಪ್ಲೇಸ್ ಮಾಡಿದ್ದೀರಿ.
ಪೇಪರ್ಸ್ ಮೊದಲೇ ಮಾಡಿದೀವಿ ಅಂತ ಹೇಳ್ತಾರೆ. ದಿಸ್ ಇಸ್ ವಾಟ್ ಮೈ ಲಾರ್ಡ್.
ಆಯ್ತು.
ಆಫ್ಟರ್ ಗೋಯಿಂಗ್ ಥ್ರೂ ದಿ ಪೇಪರ್ಸ್
That's
ಓನ್.
Yes.
ಅದಕ್ಕೆ ನೀವು ಡಾಕ್ಯುಮೆಂಟ್ ಮಾತ್ರ ಕೊಡ್ಬೇಕು, ಪ್ಲೇಸ್ ಮಾಡಿದ್ದೀರಿ ಅಂತ.
This
So you are relying this annexure H,
ಪ್ಲೀಸ್ ಮೈ ಲಾರ್ಡ್.
where
ಇವನ್ ಎನ್ಎಕ್ಸರ್ ಎಫ್ ಎನ್ಎಕ್ಸರ್ ಎಚ್ ಎಲ್ಲದ್ರಲ್ಲೂ ಡೇಟ್ ಗಳು ಬಂದಿದೆ.
ಆಯ್ತು
ಅಂದ್ರೆ
madam. For that we'll require.
ಪ್ಲೀಸ್
that.
ಎಸ್ ಮೈ ಲಾರ್ಡ್.
Yes, now
Yes.
that is.
now, my lords, kindly peruse. My lords, I have, my lords, pasted few flags, my lords, in both the compilations for my lordship's convenience.
Yes.
First of the flag is, my lords, it is the proposal submitted.
Hmm.
Flag number 1,
Yes.
18/9/2024 is the date. Kindly, my lords, refer to, my lords, reference number 2 in the said document.
Hmm.
ಮಾನ್ಯ ಜಿಲ್ಲಾಧಿಕಾರಿಗಳ ಕಾರ್ಯಾಲಯದ ಪತ್ರ ಸಂಖ್ಯೆ RB so and so dated 11/9/2024. Now, my lords, this reference, my lords, could be found at the second flag, my lords. Since these pages are not numbered, my lords, I have pasted flags. My lord, second flag, my lord, second paragraph. ಮೇಲ್ಕಂಡ ಉಲ್ಲೇಖ 2ರಲ್ಲಿ ಸೂಚಿಸಿದಂತೆ ಮಾನ್ಯರವರು ಮಾನ್ಯ ಸರ್ಕಾರದ ಸುತ್ತೋಲೆಯಂತೆ ಪರಿಶೀಲಿಸಿ ಗುಂಡಾ ಆಸಾಮಿ
Reading
the second flag, my lords.
second.
Yes. ಲೆಫ್ಟ್ ಸೈಡ್ ಸೆಕೆಂಡ್ ಪ್ಯಾರಾಗ್ರಾಫ್.
Yes.
ಮೇಲ್ಕಂಡ ಉಲ್ಲೇಖ 2ರಲ್ಲಿ ಸೂಚಿಸಿದಂತೆ ಮಾನ್ಯರವರು ಮಾನ್ಯ ಸರ್ಕಾರದ ಸುತ್ತೋಲೆಯಂತೆ ಪರಿಶೀಲಿಸಿ ಗುಂಡಾ ಆಸಾಮಿಯ ಮೇಲೆ ಹೊಸದಾಗಿ ಯಾವುದಾದರೂ ಪ್ರಕರಣಗಳು ದಾಖಲಾದ ಬಗ್ಗೆ ಪ್ರಸ್ತಾವನೆಯಲ್ಲಿ ನಮೂದಿಸಿ ಸಲ್ಲಿಸುವಂತೆ ಸೂಚಿಸಿ ಪ್ರಸ್ತಾವನೆಯನ್ನು ಮರಳಿ ಕಳಿಸಿದ್ದು ಇರುತ್ತದೆ. ಅದರಂತೆ ಮಾನ್ಯ ಸರ್ಕಾರದ ಸುತ್ತೋಲೆಯಂತೆ ಪರಿಶೀಲಿಸಿ ಸದರಿಯವನ ಮೇಲೆ ಹೊಸದಾಗಿ ದಾಖಲಾದ ಪ್ರಕರಣವನ್ನು ಪ್ರಸ್ತಾವನೆಯಲ್ಲಿ ನಮೂದಿಸಿ ಸಲ್ಲಿಸಿದ್ದು ಇರುತ್ತದೆ. So this Milord's rejection of the proposal is 11/9/2024, Milords.
First proposal.
Yes, it was rejected.
18/9.
ಅಲ್ಲ 11/9 reject ಆಯ್ತು.
11.
Yes, it was rejected. Within 7 days, not even 7 days, Milords, respondent 5 and 6, that is APMC police station, PSI, and Gol Gumbaz police station, PSI. 11/9 reject ಆಗಿತ್ತು. They prepare one more proposal on 13/9 and 15/9 within 2 days.
Where do you get that?
Milords, yes, ma'am. ಅಲ್ಲಿ ಉಲ್ಲೇಖನಲ್ಲೇ ಇದೆ, ಅದನ್ನು ಓದಿ ಹೇಳ್ಬೇಕು.
Roman
Yes, one
page
second.
number XX1 ಇದೆ.
ಫಸ್ಟ್ ಫ್ಲಾಗ್ ಅಲ್ಲೇ ಉಲ್ಲೇಖ ಇದೆ, ರೆಫರೆನ್ಸ್. ಪೊಲೀಸ್ ವೃತ್ತ ನಿರೀಕ್ಷಕರು ಗೋಲ್ ಗುಂಬಜ್ ರವರ ಶಿಫಾರಸು ಸಂಖ್ಯೆ ಸೀರಿಯಲ್ ನಂಬರ್ 4 Milords. 15/9/24. ದೆನ್ Milords, ಉಲ್ಲೇಖ ನಂಬರ್ 4 ಪೊಲೀಸ್ ಠಾಣೆ ವರದಿ ಸಂಖ್ಯೆ 300 ದಿನಾಂಕ 13/9/24. 3 days and 4 days. Once again, they submit the proposal for detention. Now kindly peruse this, Milords. As on 11/9/2024, there were 8 cases pending. Last of the case registered against the détenu was in crime number 70 of 2020-24, Milords. It was registered on 23/7/2024.
23/7.
Yes. Milords would get it at Milords flag number 4. Last.
Flag, 8 serial number.
Yes. Serial number 8. Milords make Vardi Dinanka, that is column number 3. 23/7/24. So as on 11/9/2024, this case was already pending, crime was registered, and this Milords proposal was rejected. And apart from this, Milords, absolutely
Previous rejection, let us just have a look at it. Is it there a part of the record?
no, it is not. In fact, Milords had direct.
The date, what is the date?
It is dated 11/9/24.
Yes.
So as on 11/9/2024,
There are 8 cases.
8 cases. Last of the cases was crime number 70/2024. And this proposal is submitted to the second respondent detaining authority, indicating that ಮತ್ತೆ ಹೊಸದಾಗಿ ಪ್ರಕರಣಗಳನ್ನು, there are no such new.
But there are two things.
Yes.
Now, the sponsoring authority, when it is giving a report
Yes.
to the authority
Yes.
for detention, may have made a faulty report, let us assume.
Yes.
That there is some formal defect.
Yes, maybe Milords, some
maybe.
case might have been missed.
So they may then say, no, you give a better report. Suppose the authority, detaining authority expresses its mind on merits.
Yes.
Saying that the material submitted by you in this report, there is nothing, let's assume.
Yes.
and then afterwards you give another report, same, then we can say you have not applied your mind
Yes,
to that.
yes,
So we may have to look at that. from
yes.
that
Even
angle.
assuming that what this case was not brought to the notice of detaining authority, I will go one step ahead.
One, let us have a look at that.
Yes, I will go one step ahead. Notes, assuming that this last of the crimes was not furnished before the detaining authority in the previous proposal. Notes, I will notes then at this stage, notes second time it was submitted. What is submitted?
So as per this report, only, once again, he mentioned only 8 cases.
Yes.
So ಹೊಸದಾಗಿ ನಮೂದಿಸಿದ್ದಿರುತ್ತದೆ ದಾಖಲಾದ ಪ್ರಕರಣ ಅನ್ನುವಂತ ಎಲ್ಲಿದೆ ಗವರ್ಮೆಂಟ್?
My lord, here, ಇಲ್ಲಿ ಯಾವುದೂ ಇಲ್ಲ. The 7 items which my lord preceding to the para which my friend read for remanding matter back, my lord file back for fresh proposal. Fresh proposal. My lord, according to that, my lord, again they have prepared, my lord.
Right, so what we want to know is the argument that once the sponsoring authority sent it was rejected.
And the
unless-
same again once.
That then it will amount to that on that ground only. There's absolutely no change between the early and, so suppose the authority, detaining authority said in your earlier report, there's nothing. And then says you give any other material. And if you repeatedly, if they give the same material and they act, then the detaining authority is not applied. Its mind is one inference that can be drawn. So you have to give the rejection orders, then the papers of the advisory authority.
Please.
If it is identical, then the detaining authority could not have arrived at a different conclusion without there being additional material.
Additional material is.
Only on that ground it is.
Even assuming that at the time of Lord's submitting the earlier proposal, this crime number 70 of 2020-24 was not within the knowledge of the respondent authorities, Lords. Then, Lords, I will kindly peruse this, Lords, what has been submitted along with the proposal at the second time. Page last of the flags, Lords. Last of the flags of the compilation.
Yes.
Last.
Oh,
Down.
9.
Yes, flag number 9.
Yeah.
This is only the FIR. No complaint.
This is mentioned in the earlier proposal also.
Yes, even assuming that for if lords have a doubt with regard to whether this particular document was available or furnished before the detaining authority, and for the second time, lords, this has been included. What has to be, lords, furnished for lords due application? Lords, they have to furnish the FIR, the complaint, the bail application filed by the detainee before the competent court, or the order passed therein. Lords, this FIR, complaint, bail application, lords, were filed immediately by the detainee even before lords submitting the lords this proposal. Those have been not furnished before the detaining authority. And lords may kindly peruse the statement of objections filed by lords learned government advocate. There is absolutely nothing, lords, which would to rebut these lords contentions. Lords, I can understand, lords, if they are not having the records right now for lords my lordship perusal, but at least they should say that lords the date on which they have been placed, or the lords details of the FIR, the crime, the bail application. Absolutely, in fact, lords, ಬೇರೆ ಕೇಸಿಗೆ ಆಗಿದ್ದನ್ನ statement of objection, I should not make this submission, lords, case in respect of another detainee, lords.
Copy paste.
ಆಗಿದೆ.
Yes,
Yes.
next. So you're saying placing before the detaining authority only FIR is not sufficient.
Not sufficient. Complaint has to be furnished.
First ground, same. So your first ground would be the same, the
Same
detention
material,
order on the
same-
same ground. And
As
this is same material.
same material. As
Yes.
on 11/9/2024, these crimes were already existent.
Yes. That is the first limit. Next, yavudu?
Next ground is, my lords, kindly peruse the, my lords, flag number 3. How this, my lords, the sponsoring authorities, they have, my lords, acted in haste. Flag number 3 on the left side, my lords, last but 3 lines. ಮಾತನಾಡುವ ಭಾಷೆಗಳು, this is with respect to detenue, my lords. ಕನ್ನಡ, ಹಿಂದಿ ಹಾಗೂ ಮರಾಠಿ. ಓದಲು ಬರೆಯಲು ಬರುವ ಭಾಷೆಗಳು ಕನ್ನಡ ಮತ್ತು ಹಿಂದಿ. Then, my lords, the next page, my lords, ಸಂಬಂಧಿಕರ ವಿವರ. ಹೆಂಡತಿಯ ಹೆಸರು ಮತ್ತು ವಿಳಾಸ, ಮದುವೆ ಆಗಿರುವುದಿಲ್ಲ. Now, the petition is filed by the wife. She has submitted a representation to the department against the detention order,
So non-application of mine.
non-application, and they have not, given the true facts before the detaining authority. He has a son. I have produced the birth certificate along with my writ petition. Why this, lords, in such a hurry?
Yes.
They don't, lords, give the proper or true particulars regarding the detenue before the detaining authority, which could have, lords, weighed in some or other, one or the other way in passing the order of detention.
Think that they have not placed full material.
Material,
So
my
the fact
marital
that he is
state-
married and having children
children,
may have been a factor for
factor,
the detaining authority.
detaining authority, he might have, lords, meant his way of living,
Not placing full material before the
not
detaining.
placing full material. I have produced them. In fact, wife, she has also made a representation to the department, which is rejected by the endorsement, annexure E. He has a son. I have produced, lords, birth certificate, annexure A, wherein
Annexure A to the writ.
writ, lord. Petitioner. Annexure A, wherein petitioner is shown to be his wife and a son, lords, by name Manikanta. Then, lords, I read, lords, the educational this thing because 3 of the judgments passed in cases against which, in which detenue was involved, are in English language. That is, it starts,
Translation on
no translation.
that
Well,
is-
it starts from, lords, page number 117 rinda 260, 271 varagade. Sorry, there are 3 judgments, lords, 2 by the trial court,
1172, 26,
lords, 117 is in respect of SC number
1172.
117 to 151. 151 into bracket Roman 1, 2. Lords, 151 into bracket Roman 15. This judgment is in Criminal Appeal 3649 bar 2012 passed by this honorable court. And again, lords, at page number 258 to 269. That is in criminal case number 4450 of 2021.
All of this in English.
English. Translated copies either to Kannada or the other language which is known to the detainee are not furnished. So, my lords, my submission is, I have
Judgment ಮತ್ತೆ ಬರೋಣ.
Huh?
Judgment ಬರೋಣ next.
Yes.
Next one, incomplete document.
incomplete document. Incomplete document, incomplete information regarding the background of the
Yes, yes.
detainee.
So incomplete information is different and incomplete document.
Document.
So what are the documents incomplete
The FIR, only FIR is produced,
in the last case?
last case. Complaint, the bail application, lords, why this is important is
He was on bail in that case.
subsequent to detention, lords, he was granted bail, but because of this detention order, he has been continued in custody because this crime number, lords, ಯಾಕಂದ್ರೆ this crime number 70 of 2024 lords, it was registered on 23/7/2024. Detainee files bail petition on lords 4/9/2024. That is even prior to submission of the lords proposal. But those documents were not submitted before the detaining authority for the reasons best known to them. It is not a case where I did not approach court of law seeking bail. Records are there. Even prior to submission of proposal, I have applied for bail on 4/9. And these proposals, they are submitted on 16/9 and 15/9 and 13/9.
It may not come to your aid. So as per the non-supply of the complaint copy.
Complaint copy.
Complaint copy.
Yes.
The FIR is there, my lord, wherein
You to submit an effective
Representation, effective representation.
So the non-furnishing of this copy of the complaint
Complaint.
with the compilation.
Yes.
Huh?
Yes.
You were in custody
Yes.
till the date of the order of detention,
Yes.
isn't it?
As on the date of
he was
21/9,
in custody.
21/9/2024. Maybe, lords, this, the last of the crime, lords, was registered with this since it was earlier rejected. So to somehow, lords, to bring him within this detainee under the provisions of this act, maybe this, and the complainant is a friend there.
ಇದೆಯಾ legible copy ಅದೇನಾದ್ರೂ ground ಇದೆಯಾ? Have you raised
Well,
it?
ಇಲ್ಲ, ಇಲ್ಲ. ಅದೇನ್ because not
Thakur doesn't want to come so low. Yes,
I have tried not, but I thought I should not trouble your lordship with those.
You should not. You have to raise some legal points. That legible copy and other.
ಅದಕ್ಕೆ ನಾನು raise ಮಾಡಿ.
So what is your next submit, next to this
So,
one?
Lord, sir.
Grounds of,
I just want to know, now representation opportunity is given, isn't it? Now the reason or ground taken is that complete documents were not furnished to enable you to make an effective representation. So till the date of the representation made, were you in custody?
Yes, I was in custody. Date on detention 21/9/24. Date of making representation is 25/9/2024.
any other ground?
These are
Now, lastly, the representation, this one, not placed before the detention order, not placed before the
advisory board.
within 21 days. So must be 5 grounds,
Yes,
these are the 5 grounds.
5 grounds.
Please,
Your officer must be present. It paints a very bad picture. Last time she came, now it is in their interest if they want to seriously contest, isn't it? They must come assist you also. They can't,
Here,
they
my
can't
lord,
simply say notorious fellow and leave it at that. You have to defend the order. isn't
properly,
it?
yes. My lord, my submission with regard to the non-production of the entire papers is, my lord, here column number 10 of the FIR itself is sufficient. The whole things, my lord, which is the complaint is having, the same is narrated. My lord, who is the complainant, what my lord has done, the only one single complaint paper is missing,
government,
my lord.
the casual approach, the casual manner in which you invoked Gunda Act and your subsequent casual approach, we are making it clear that once we come to the conclusion that this has to go, then we will impose cost. We will impose heavy cost. Let your officers pay
My lord, the-
for detaining him in the prison for 5 to 6 months. Let them pay from their this one salary. We'll impose cost. This is not the way. We are also observing from last 2 months, your officers are not present. They're coming to the court, or they are not interested to pursue this matter effectively. This is not the way. The casual approach. In a case of Gunda Act, preventive detention.
Yes, my lord. I am sorry to say, yesterday also some constable has brought those documents and to throw telephonically, they have said they are unable to get that.
Invoke ಮಾಡಿದ
I
sponsoring
request our
authority and
lordship to summon, my lord, secure that advisory board report.
sponsoring authority ಮತ್ತು confirming authority, or let them pay the cost. We will impose some cost. So casual approach, that is the reason you said. ಮತ್ತೆ ಲಗತ್ತಿಸಿದೆ ಎಲ್ಲಿದೆ? Where is the new case? The same with 8 cases.
Earlier,
What are the grounds of detention in their order?
This involvement of notes,
Let us just have a run through that.
yes. First page. Lords, grounds of detention, Lords, page number 30, Lords, of
Page?
my writ petition. It is page number 30, translated copy, English trans. They, Lords, state that much he was involved in 8 cases. Details of the 8 cases are given. That is up to page number 35. Page number 36, Lords, paragraph 4.
What are the nature of the cases?
302 cases, murder case in one murder case, Lords, he is acquitted by this honorable court. It could be found at page number 31. First of the case, acquitted. Second, Lords, 2017 at the stage of inquiry. Third case, he is acquitted. Fourth case, it has ended in a compromise before Lok Adalat. You-
In the fourth case, they threatened the complainant to, my lord, enter into compromise. This is,
ಇಲ್ಲ ಕೋರ್ಟ್ನಾಗ ಲೋಕ್ ಅದಾಲತಲ್ಲಿ ಸೆಟಲ್ ಆಗಿದೆ.
in the fourth case, APMC
Fourth
police
case.
station.
ಅವ್ರು ಹಂಗ ಅನ್ಕೋತಾರ ಬಿಕಾಸ್ ಆಫ್ ಹಿಯರ್ he has and kindly peruse this, Lords, page number 36. It gives last but one paragraph, Lords. Therefore, in order to prevent your antisocial criminal activities and to maintain peace and public order, I hereby on no date 9/24 order to detain you. It is either antedated
In all the other criminal cases that they've referred in grounds of detention, Did they give copies?
Yes, this is what it,
All.
yes,
So only in the last matter,
last,
they have not given.
the basis, which was the basis.
For
to
the
pass.
second report.
Yes,
Huh?
yes. ಯಾವ್ದನ್ ಬೇಸ್ ಮಾಡಿಕೊಂಡು detention order was passed, that document itself was not submitted incomplete. Because all other documents were earlier also lords as per this thing were available.
ಯಾವಾಗ ತರ್ತೀರಿ ಗೌರ್ಮೆಂಟ್
My lord,
ಯಾವಾಗ ತರ್ತೀರಿ ರಿಪೋರ್ಟ್ ತರ್ತೀರಾ ಅಲ್ಲ ಹಂಗೆ ಆರ್ಗ್ಯುಮೆಂಟ್
We'll
ಮಾಡ್ತೀರಾ
pass an order,
my lord.
but you must keep it present on the next date, those documents. So how much time you require? We'll pass the order today and we'll fix the date.
2-3 days, my lord. Next week, I'll have. I request your lordship for judicial order for getting the
Very-
paper.
very-
Please.
You must be as strong as you, now you are strong. Police strong ಇರ್ಬೇಕು.
Heard, heard Shri Mamadapur for the petitioner. However, petitioner, however, the government advocate raised a short accommodation to submit the documents, full stop. In the course of argument, we have gone through the materials placed by the learned counsel for the petitioner, full stop. The material documents relied by the sponsoring authority in the proposal sent for the
Detention.
sent for the proposal sent for detention by the sponsoring authority, comma, to the documents, that is the proposal made, the document, those documents are not forthcoming in the record, full stop. As such, on the record, addition, as such, the government advocate is directed to produce, please, the documents mentioned in the proposal, dated 18/9/2024 at reference number 125. Additionally, comma, the government advocate also directed to place the proceedings of the advisory board. Proceedings of the advisory board in a sealed cover. On Yavaga. On 10/10/2025.
Please.
ಟೆನ್ ಬೇಡ ಸ್ವಾಮಿ, ಅದಕ್ಕಿಂತ ಮಂಗಳವಾರ ಅಥವಾ ಬುಧವಾರ ಕೊಡಿ ಸ್ವಾಮಿ.
Next,
ಹಾ. ಬುಧವಾರ ಅಥವಾ ಗುರುವಾರ, ಶುಕ್ರವಾರ ಅಂಡ್ ಮಂಡೇ.
12th ಆಗುತ್ತಾ?
ಇಲ್ಲ, ಬಿಫೋರ್ ದ್ಯಾಟ್, ನೆಕ್ಸ್ಟ್ ವೀಕ್.
ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಬೇಡ. ಆನ್ ವೀಕಲ್ಲಿ ಯಾವ್ದು ಬೇಕು ಕೇಳಿ. 10th
12th,
ಬೇಡದ್ರೆ ಬೇರೆ ಯಾವ್ದಾದ್ರು ಆಗ್ಬೋದಾ?
12th.
45-12. 45-12 ಅಂತ ಮಾಡಿ.
Please.
If the documents are received in advance
Yes,
by the government advocate, you inspect it
yes,
or you take his permission and inspect. it.
yes, in his presence
You see the difference between the earlier proposal and
let
and
second,
point out from that both proposal, what is the difference according to you?
please,
Or there is no difference?
yes.
SC/ST, yeah?
My lords,
SC/ST.
ಇಲ್ಲ 376.
Phone number is phone ಮಾಡಿ.
376 and SC/ST ಅಲ್ವಾ?
The main offense. Three, two, five. My lords,
Your first submission would be, this is the judgment of so and so, so. and so.
already I submitted, my lords. Though, my lords, in this case, there are so many discrepancies and improvements that is there, my lords. Then also, I have to submit, my lords. In all the prosecution of examined PW.
ನಮ್ಮೂರು beneficiary ಇದ್ದಾರೆ. ಅದಕ್ಕೆ ಒಂದು grant ಮಾಡ್ಬೇಕು.
In all the prosecution of examined PW 1 to PW 12. So amongst them, my lords, the PW 1, 2 are the spot punchers. And PW, they have not supported the case of the prosecution.
So just let us see the complaint.
Come.
What she has.
Shall I read, my lords?
She was major, she was
Yes, she was made.
25 years, ST. right?
Ah.
So in your major,
She was
So
major,
there is a
25
delay.
years, 25 years old, and they were very much known to each other, and they were doing job in some institute.
No,
Consensually. Yes.
exhibit P3.
Exhibit P3 in page number 5. ನಾನು ತ್ರಿವೇಣಿ ತಂದೆ ಈಶ್ವರ್ ಸಂತೆ ವಯಸ್ಸು 25 ಜಾತಿ ಪರಿಶಿಷ್ಟ ಮುಖಮು ಗಾಂಧಿನಗರ ಹುಮನಾಬಾದ್ ನಿವಾಸಿ ಇದ್ದು ಈ ಮೂಲಕ ಅರ್ಜಿ ಬರೆದು ಸಲ್ಲಿಸುವುದೇನೆಂದ್ರೆ ನಾನು ವಿದ್ಯಾವಂತ ಮಹಿಳೆ ಇದ್ದು ಬೀದರ್ ವೆಟರ್ನರಿ ಕಾಲೇಜಿನಲ್ಲಿ ಕಂಪ್ಯೂಟರ್ ಆಪರೇಟರ್ ಅಂತ ಕೆಲಸ ಮಾಡ್ತಿದ್ದೆ. ಸುಮಾರು 2.5 ವರ್ಷಗಳಿಂದ ಹೌಸಿಂಗ್ ಬೋರ್ಡ್ ಕಾಲೋನಿ ನಿವಾಸಿಯಾದ ಗಿರೀಶ್ ತಂದೆ ಜಗದೀಶ್ ಅಸ್ಟಿಕರ್ ಜಾತಿ ಬಹುಸಾರ್ ಛತ್ರಿ ಮರಾಠ ಸೇರಿದವನು. ನಾನು ಪರಿಶಿಷ್ಟ ಜಾತಿಗೆ ಸೇರಿದವಳೆಂದು ಗೊತ್ತಿದ್ರು ಕೂಡ ನನ್ನ ಜೊತೆ ಪ್ರೀತಿ ಮಾಡಿ ನಂಬಿಸಿ ಮದುವೆ ಮಾಡಿಕೊಳ್ಳುತ್ತೇನೆ ಎಂದು ಹೇಳಿ ನನ್ನ ಜೊತೆ ಲೈಂಗಿಕ ಸಂಪರ್ಕ ಇಟ್ಟುಕೊಂಡಿದ್ದ. ದಿನಾಂಕ 28/8/2013 ರಾತ್ರಿ 8 ಗಂಟೆಗೆ ನಾನು ಎಂದಿನಂತೆ ಗಿರೀಶ್ ಅವನ ಮನೆಗೆ ಹೋದಾಗ ಅವನು ಏಕಾಏಕಿ ಮಾತು ಬದಲಾಯಿಸಿ, ನೀನು ಒಲೆ ಜಾತಿಗೆ ಸೇರಿದವಳು, ನಾನು ನಿನ್ನನ್ನು ಮದುವೆ ಮಾಡಿಕೊಂಡ್ರೆ ನಮ್ಮ ಮನೆಯವರು ಒಪ್ಪೋದಿಲ್ಲ, ಇನ್ನು ಮುಂದೆ ನೀನು ನನ್ನ ಹೆಸರಿಗೆ ಬರಬೇಡ, ನಾನು ಬೇರೆ ಮದುವೆ ಮಾಡಿಕೊಳ್ಳುತ್ತಿದ್ದೇನೆ, ಇನ್ನು ಮುಂದೆ ನೀನು ನನ್ನ ಮನೆಗೆ ಬಂದರೆ ನಿನ್ನ ಮೇಲೆ ಆಸಿಡ್ ಹಾಕಿ ಸುಟ್ಟು ಹಾಕುತ್ತೇನೆ ಅಂತ ಜೀವದ ಬೆದರಿಕೆ ಹಾಕಿ ನನಗೆ ಕೈಯಿಂದ ಹೊಡಿಸಿರುತ್ತಾನೆ. ಈ ವಿಷಯ ನಾನು ನಮ್ಮ ಮನೆಯವರಿಗೆ ತಿಳಿಸಿದಾಗ, ನಮ್ಮ ತಂದೆಯವರು ನಮ್ಮ ಜಾತಿಯ ಲಕ್ಷ್ಮೀಪುತ್ರ ಮಾಳಿಗೆ ವಿನೋದ್ ಸಾಗರ್ ಅವರಿಗೆ ತಿಳಿಸಿದಾಗ ಅವರು ಬಂದು ನನಗೆ ವಿಚಾರಿಸಿ ನಮ್ಮ ತಂದೆ ಜೊತೆ ಅವರ ಮನೆಗೆ ಕರೆದುಕೊಂಡು ಹೋಗಿ ಗಿರೀಶ್ ಅವನಿಗೆ ವಿಚಾರಿಸಿ ಕೇಳಿದಾಗ, ಗಿರೀಶ್ ಅವನು ನನಗೆ 15 ದಿವಸ ಸಮಯ ಕೊಡ್ರಿ, ಆಮೇಲೆ ಹೇಳುತ್ತೇನೆ ಅಂದ. ಅಂದಿನಿಂದ ಅವನು ನನಗೆ ತಪ್ಪಿಸಿಕೊಂಡು ಓಡಿ ಹೋದನು. ದಿನಾಂಕ 29/2013 ಸಾಯಂಕಾಲ 6 ಗಂಟೆಗೆ ಹುಮ್ನಾಬಾದ್ ಅಂಬೇಡ್ಕರ್ ಸರ್ಕಲ್ ಹತ್ತಿರ ಗಿರೀಶ್ ನಿಂತಿದ್ದು ನೋಡಿ, ನಾನು ಅವನ ಹತ್ತಿರ ಹೋಗಿ, ಎಷ್ಟು ದಿವಸ ಎಲ್ಲಿಗೆ ಹೋಗಿದ್ದೆ, ನಾನು SC ಜಾತಿಯವಳೆಂದು ನಿನಗೆ ಗೊತ್ತಿದ್ದರು ಕೂಡ ನನ್ನ ಜೊತೆ ಮದುವೆ ಆಗುತ್ತೀನಿ ಅಂತ ನಂಬಿಸಿ ನನ್ನ ಜೀವನ ಹಾಳು ಮಾಡಿದ್ದೆ ಎಂದು ಕೇಳಿದ್ದಕ್ಕೆ, ಅವನು ನೀನು SC ಜಾತಿಯವಳು ಮತ್ತು ನಿನ್ನ ಗುಣ ನಡತೆ ಸರಿ ಇಲ್ಲ, ನೀನು ನನ್ನ ಹೆಸರಿಗೆ ಬರಬೇಡ, ಮತ್ತೆ ನೀನು ನನ್ನ ಹೆಸರಿಗೆ ಬಂದರೆ ನಿನ್ನ ಕೊಂದು ಬಿಡುತ್ತೇನೆಂದು ಜೀವದ ಬೆದರಿಕೆ ಹಾಕಿದೆ. ನನಗೆ ಗಿರೀಶ್ ಮದುವೆ ಮಾಡಿಕೊಳ್ತೇನೆ ಎಂದು ನಂಬಿಸಿ ಮಧ್ಯದಲ್ಲಿ ನನ್ನ ಕೈயை ಬಿಟ್ಟು ನನ್ನ ಜೀವನ ಹಾಳು ಮಾಡಿದ್ದಾನೆ.
ಯಾವುದೋ ಒಂದು ಅಪೀಲ್ ಇತ್ತಲ್ಲ, ಮೆಂಟಲಿ ರಿಟಾರ್ಡೆಡ್ ಮೈನರ್ ಗರ್ಲ್
Yes.
ರೇಪ್, ಅದೇನಾಯ್ತು ಅದು?
ಅದು ಇನ್ನೂ ಮುಂದಿದೆ ಸರ್.
ಹಾ?
ಅದು ಆಗಿಲ್ಲ, ಇನ್ನೂ ಆಗಿಲ್ಲ ಸರ್.
ಕಂಪ್ಲೇನೆಂಟ್ ಅಪೀಲ್ ಇತ್ತು ಅಲ್ಲ?
ಹೌದು.
ಅದ್ರಲ್ಲಿ ಸ್ಟೇಟ್ ಹಾಕಿರ್ಲಿಲ್ಲ.
ಹೌದು, ಇಲ್ಲ ಇತ್ತು.
ಅದ್ ಹೆಂಗ್ ಸ್ವಲ್ಪ ನೋಡಿ ಅಂತ.
ನಾನು ಲೀಸ್ಟ್ ಮಾಡಿಸ್ತೇನೆ ಸರ್, ಮಾಡಿಸ್ತೇನೆ. It was listed thrice, my lords, that matter, my lords. The appellant was present and he took a time for thrice for interesting advocate. But I'll make it list. Yes. So accordingly, she lodged the complaint on 29/2013 at 9 AM.
Ah.
And exhibit,
After 22 days, huh?
yes, my lords, after
Hmm.
22 days. Though, my lords, they were in consensual love affair. And they had a sexual intercourse, as she has stated in her evidence also. She has been tried by the court as a PW4.
Hmm.
And she supported and she narrated pertaining to illicit
What is the evidence?
PW4, my lords, PW4. In page number 30, my lords. In second paragraphs.
Hmm.
In the year 2013, for about 8 to 9 months, I had worked as junior assistant at Veterinary College, Bidar. I know the accused since from 3 years. I fell in love with the accused who assured myself that he would marry myself. On assuring myself, the accused had a physical union, perhaps had a sexual union with myself. While the accused had assured myself that he would marry, therefore I submit myself to the accused and allowed him to have a sexual intercourse.
Hmm.
Sexual intercourse. Once or twice in a week, the accused was using to take myself to various places like Gulbarga, Hyderabad, and Chakur. Here he was, where he was using to have the sexual intercourse with myself. One Praveen, the friend of the accused,
Hmm.
was having computer institute and I was using to met the accused in the said computer institute. Besides, my friend Sridevi had her house at Gulbarga. Therefore, myself and accused were using to pay a visit to the said house at Gulbarga, where myself and accused were using to have the sexual intercourse. Whenever I was asking the accused to marry myself, he was using to told me that he would convince his father and mother. Therefore, he required time. As such, he took 6 months' time. During that period, some persons came to my house for marrying myself. However, accused told that he would myself. Therefore, I was not prepared to marry others. Therefore, I lost new relation. The accused was using to call myself for the mobile phone, gradually reduces to call myself. Therefore, I met Vinod, the friend of the accused, and told that the accused had reduced his phone calls, who told myself that the accused was preparing to marry another lady. Therefore, he reduces the myself and accused were having the contact over the web camera internet. The accused was using to use unparliamentary words whenever he was in contact with myself through the above media. In para 7, my lords, whenever I was using to ask the accused to marry myself, he was using to told myself that he would convince his mother. Therefore, he required time. In the month of March 2013, while I had collected the information that the accused was to pay his visit to the house of the bride for the selection to marry, I met the accused and asked him why he was searching bride. He told myself that for the formality he is searching bride. He also told myself that he would not marry any other bride except myself. He promised on the God regarding his marriage with myself. In the said month, I went to Gulbarga since accused had told myself he would bring his mother and she would see myself and he would convince his mother. I waited for the accused till 8 p.m. and placed my efforts to contact him over the mobile phone. He did not receive the call. It was about 9:30 p.m. I returned to Humnabad. I went to the internet cafe of the accused. He, on seeing myself, escaped from the said shop to his house by his motorcycle. While accused was proceeding towards his house by motorcycle, I followed him by the auto. He did not return his home. However, he hiding himself in the shed under the tree, in the shade under the tree. While asked the accused as to why he made myself to wait at Gulbarga not coming forward to marry myself. He told that I belong to Hindu community. Therefore, his mother was not agreeing for the marriage. Therefore, he could not marry myself. The accused was started to abuse myself by using filthy words. Therefore, I have frustrated a lot and took the blade and inflicted injury on my left wrist with an intention to commit suicide. This is the improvement where in the chief examination, my lord. This particular portion is not in the complaint. There was bleeding. The accused on seeing the bleeding went away. Even after bleeding also, she did not go to the hospital anywhere. That is the chief examination. Then Praveen and Prakash came there, who provided an water to myself and took myself to bus stand at Humnabad. They called the accused over the mobile phone, who came to the bus stand at Humnabad. The accused told myself that he would marry myself and asked myself be in the house of my friend. Therefore, I boarded in the bus and went to Gulbarga. On the following day, while I was in Gulbarga, I placed my efforts to contact the accused over the mobile phone. I noticed that his phone was switched off. Then I called Praveen, the friend of the accused, over the mobile phone, who told myself that the accused was busy in the function. Therefore, he took him on the following day. I waited for the accused and Praveen on the following day. However, both were not come to the Gulbarga. However, I received the phone call from the accused, who seems to be under the influence of alcohol. He used the abusive words like but he abused in filthy and told that why I was hurry for the marriage. On the following day, the accused started his phone contact and he was called myself over the mobile phone and tried to console myself. On the following day, while I called the accused over the mobile phone, I noticed that he was in Maharashtra. However, he did not respond my mobile call. Then I called his friend Vinod over the mobile phone and asked him whereabouts of the accused, who told myself that he had seen the girl at Maharashtra and he would marry within short period. On 28/8/2013 at about 8 p.m., I had been to the house of the accused. He was in the house. I inquired him as to why he was placing his efforts to marry others, for which he told myself that since I am belonging to a caste, therefore he would not marry myself. He had also assaulted myself with the hands, perhaps thrown myself away from his house. He told myself that if I would return his house for asking the marriage, he would put acid to my face. Then I returned home and told my father and mother regarding the conduct of the accused. Then my parents took the matter to the elderly persons by name CW8. That Vinod, he is also PW8, my lords, and CW9 Lakshmiputra Malge, he is examined as a PW9. Lakshmiputra Malge of my caste. Then on the same day at about 10 p.m., my parents, myself, CW8 and CW9 went to the house of the accused, where we found the accused along with his parents, to whom my parents and CW8 and CW9 told that the accused had deceived myself, therefore he was to marry myself, for which the accused, his parents told that they require 15 days time to think over the matter. After 15 days, I placed myself, my efforts to contact the accused over the mobile phone, and I found that his mobile phone was switched off. He was avoiding myself. On 29/2013 at about 6 p.m., while I was purchasing vegetable near the Ambedkar Circle, the accused met in the way, to whom I inquired the 15 days time has already over, what he had think over about our marriage, for which he told myself that since I am belonging to a civil community, therefore he could not marry myself. He told the accused that he was aware of my cars while he fell in love with myself, proceeded further to have the sexual intercourse. He told myself that I had no good character, besides his mother was not agreeing for marriage, therefore he could not marry myself. He abused myself by using the word Suli and told that he had already made clear that he would not marry myself. I returned home, informed the said facts to my parents. Then my parents took myself to the police station, where I lodged the written complaint. That is Exhibit P3. And this is the chief examination.
PW4 ಅಷ್ಟೇನಾ?
PW7 is the father.
Father.
PW8 and 9 are the persons who try to pacify the matter, who belongs to the caste of
8 father,
PW7 members.
PW7 father.
Father.
Ah.
PW8 is a victim's caste person and PW8 and 9 both.
8 and 9.
Yes, my lords. They have supported the case of the prosecution.
And panchayat antla.
Somewhat panchayat. They had been to the house of the accused
After the incident.
after the incident.
That's all. Medical
Yes.
is it?
Yes, ma'am.
What is the medical evidence?
Nothing, sir.
Any doctor has been examined?
Examined. PW10 members.
Hmm.
PW10 is a doctor.
What is this?
Doctor say 58 page number. 58 minutes.
Hmm.
On 21/9/2013, while I was working as LMO Government Hospital, Umnabad, PW4 was taken to myself for her examination. I have subjected her to the examination, found that she was physically and mentally fit for sexual acts. Accordingly, I have issued a certificate to the effect which is marked as Exhibit P6.
Just it.
That's it. And PW11 is the person who has registered the case, my lords. And PW12 is I.
Disappointment from me. State has preferred. State has preferred this appeal against the judgment passed in special C number 1 of 2014 dated 4/8/2014 by the special judge and additional district and sessions judge at Vide, whereby the year and after the special judge anta, whereby the learned special judge has acquitted the accused respondent for the offense punishable under section 323, 506, 376 and 420 of IPC and section 3, subclause 2, subclause 5 of SC/STs bracketally prevention of atrocity bracket closed Act 1989.
Sorry for the interference, my lords. Even it doesn't fall under the section 376, my lords, whether it comes under 420.
420 ಬರಲ್ಲ 420 ಅಲ್ಲಿ ಯಾಕೆ ಬರಲ್ಲ ಅಂತ ಹೇಳಿದ್ರೆ
Sir.
where is the promise culpable intention right ಇದು ಪ್ರಾಮಿಸ್ ಬೇಕಲ್ಲ dishonest intention fraudulent or dishonest intention.
Then he used her for sexual intercourse, my lords, by promising marry with him, with her.
But also love ಅಂತ ಹೇಳ್ತಾರೆ ಅಷ್ಟೇ.
ಹೌದು.
It's a love affair.
Yes, 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 my lords. That is the word only.
That is
Other,
the admission. Love affair.
yes,
If that is a love affair, that is admitted by PW4. If that is the case, then there is no
The-
question of
yes.
promise.
it's a yes. If that particular word did not appear, the thing would have 428.
Hmm.
She admitted. She herself has stated. that.
She herself admitted.
Yes.
ಲವ್ ಅಫೇರ್ ಅಂತ
Yes,
ಚೀಫ್
madam.
ಅಲ್ಲಿ ನೋಡಿಬೇಕು
ಇದೆ ಸರ್, ಕಂಪ್ಲೀಟ್ ಅದೇ ಇದೆ.
ಅದೇ ಇದೆ ಲವ್ ಅಫೇರ್ ಅಂತ.
4 para, she narrated pertaining to that aspect only. She used to go somewhere else along with him and all those things.
ಲವ್ ಅಫೇರ್ ಆದ್ರೆ ಮತ್ತೆ ಬರಲ್ವಾ?
ಬರಲ್ಲ.
King Baraga. The factual matters of the case are in brief that the PW4, she herself is the complainant. alva?
Yes.
Herself is the
Yes.
complainant. PW4, the victim in this case is the member of scheduled caste and she belongs to Hindu Korean community. She happens to work as a supervisor in other unique identification authority in the year 2012, where the accused was her co-worker. Also, thereby they both fell in love each other. By also, the accused by taking advantage of such friendship, developed illegal intimacy, developed intimacy with her and also had physical union, the physical affair with her by assuring her to marry. Full show. Thereafter, he fails to marry. Thereafter, he fails to fulfill his promise. On this backdrop, on 28/8/2013, at about 8 p.m., the accused respondent at his house at Humnabad, the victim went and the victim went there and, he all of a sudden abused her in filthy language by mentioning her caste name. Caste name. Further, he also informed her, also stated that since she belongs to scheduled caste, he'll not marry her. Full show. If she force him to marry her, he will throw acid on her. Full show. There are full show. Subsequently, the said aspect was informed, brought to the knowledge of her parents, and they also made an effort to pursue the accused. However, pursue the accused. Full show. On later on 29/2013, pursue the accused, which went in vain. On 29/2013, at about 6 p.m., when the accused was standing near Ambedkar Circle, Humnabad, the victim inquired him about the promise assured by him that he'll marry her, about the marriage, about marrying her. Full show. Marrying her. However, the accused once again threatened her, abused and threatened her with dire consequence and also assaulted her and also caused hurt on her. Full show. As such, the victim lodged the complaint before the complainant police, as per exhibit, before the complainant police on 29/2013, as per exhibit P3. Full show.
FIR is exhibit P7.
P3. On the strength of exhibit P3, the respondent police, the complainant police, registered the case in crime number 197 of 2013, dated 29/2013, against the accused for the offense punishable under section 3 subclause 2 subclause 5, 3 subclause 1 subclause 12 of prevention of SC and the ST bracketally Prevention of Atrocity Act and section 493, 506, 417 of IPC, full stop. Later, the investigation officer PW
12.
PW 12, 12 after recording the statement of all the material witness. So also material witness, laid the and also obtaining the necessary documents from the concerned authority, laid the charge sheet against the accused respondent for the offense 493, 417, 506 of IPC and section 3 subclause 1, 12, 32, same other narrative of PC Act before the special judge, before the special court, full stop. The after next, the special court to prove the case of the prosecution case before the special court, to prove the case, to full stop. The learned session judge the learned session judge, thereafter the learned session judge framed the charges against the accused for the said offences. However, he denied the same. In order to prove the charges leveled against accused, the prosecution in total examined 12 witnesses. So also got marked 8 documents. Exhibit P1 to P8 and full stop. P8. Next, after the assessment of the oral and documentary evidence, the learned special judge acquitted the accused for the charges leveled against him. Full stop. The said judgment is challenged in this appeal by the state. We have heard the learned additional SPP for the state appellant state. So also Nimesrin
Sir, Santosh Patil.
Shri Santosh Patil.
I seek apology.
Santosh Patil for the respondent accused. Full stop. The learned additional SPP, the primary contention of the learned additional SPP is that the trial judge, the learned special judge has failed to appreciate the evidence of PW4 to prosecutors in a right perspective. Full stop. In a full stop, right perspective. PW, she has stated in her complaint exhibit P3, so also in her evidence before the court that the accused committed sexual intercourse on her for a period of 2.5 years.
Yes.
2.5 years. On the promise of marrying her. Full stop. However, thereafter, he threatened her with the dire consequence and also assaulted on her. Full stop. In such assaulted on her. Full stop. The said evidence of PW4, clearly corroborates to the evidence of our father PW7. 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 Full stop. PW7. Further, PW8 and 9. The PW8 and 9 also stated that after the stated that the accused a panchayat was held in respect of panchayat was held between the accused and the victim in respect of the love affair between them so also love affair between them, so also the promise given by the accused to marry the deceased, marry the victim, in marry the victim. In such circumstance, the session judge ought to have appreciated the evidence of the PW4 and convicted the accused for the offense he has charged. Full stop. The learned SPP also contend that by knowing knowing fully well that the victim was belongs to scheduled caste and scheduled tribe community, the accused intentionally committed rape on her by promising to marry her. Full stop. In such circumstance, the impugned judgment is liable to be set aside, and the accused may be convicted, convicted for the charges leveled against him. Full stop. Per contra, the learned counsel for the respondent accused submit that the learned session judge has elaborately discussed the evidence of the prosecutrix PW4, which reveals that it's a clear case of it's a clear case of clear case of false implication of the accused on the implication of the accused for the reason that the family members of the family members of the accused were not willing to perform the marriage of accused with the victim, full stop, with the victim.
More especially mother, my lord.
With the victim in such circumstance, victim, full stop. Further, the evidence of PW4 clearly reveals that at no point of time, the accused performed sexual act with the victim by promising her to marry her, with the promise of marry her, full stop. In marry her, full stop. The prosecution also failed to prove the aspect that the accused had the knowledge that the victim belongs to scheduled caste at the scheduled caste while scheduled caste, full stop, scheduled caste, and as such scheduled caste, full stop. As such the offense the prosecution failed to prove the charges for the charges under the provisions of IPC or under the provisions of SC/ST Act. Accordingly, the session judge has rightly acquitted the accused from the charges leveled against him. Accordingly, he prays to dismiss the appeal. Also, having heard the learned counsel for the respective parties, the only point that would arise for our consideration is whether the judgment under this appeal, whether the learned session judge is justified in acquitting the accused for the charges leveled against him, and interference is required in the impugned judgment. Full stop. As could be seen from record, full stop. As could be seen from the Albanian, we have carefully perused the entire evidence available on record. So also the documents placed before us. As could be seen from records, in order to prove the charges leveled against accused, the prosecution has predominantly relied the evidence of PW4, that is the victim, that is the prosecutrix. Yes. Well, on prosecutrix in this case, on careful perusal of our evidence, she has categorically stated that herself and the accused were in love affair with the love affair for a period of 2.5 years prior to lodging the complaint. prior to lodging exhibit P3.
Yes.
Exhibit P3, full stop. The P3. It is further, she also admitted in her evidence that, for that the herself and the accused went to several
Gulbarga,
places.
Gulbarga, Hyderabad, Chaco.
Went to several places, went to various places like Gulbarga, Hyderabad, and
Chakur.
Chakur, where Chakur and used to once or thrice in a week, full stop, thrice in a week. Further, it is also admitted by her that she used to visit the house of accused often.
Yes.
Accused often, full stop. Full stop. Full stop. Full stop. However, it is nowhere, however, on perusal of our evidence, it's nowhere stated that the nowhere stated that the love affair, nowhere stated that the accused, nowhere stated about the alleged act of alleged sexual act committed by the accused, specifically the date and time.
Yeah.
Date and time in this in exhibit, either in exhibit P3 or in her evidence before the
Yes.
court, before the court. Moreover, there is a delay of 22 days in lodging
Lodging.
exhibit P20, exhibit P3, full stop. The exhibit P3 on further in exhibit, on perusal of exhibit P3, the same depicts that, they both were in love affair. The accused and prosecutors were in love affair, and all of a sudden on 28/8/2013, the accused threatened her, threatened her that he'll not going to marry her. Full stop. Marry her. In such a circumstance, marry her. And thereafter, a compromise was held. Subsequently, a compromise was, a panchayat was held to that effect. Hence, it is clear that, the said aspect was reiterated by PW4 in her evidence. In such circumstance, it could be gathered that it could be in such circumstance, it is proved that the accused had not made any such promise to marry her. Per contra, they both were in love affair.
Yes.
With 2.5 years.
Yes.
Prior to date of lodging exhibit P3. Exhibit P3, full stop. In order to attract the provision of section 420 of IPC, 420 of IPC, number 1, there should be a fraudulent or dishonest inducement of a person by deceiving him, the person, next, the person deceived, the co-deceived should be induced to deliver any property to any person or to consent that any person shall retain any property, or B, the person so deceived should be intentionally induced to do or omit to do anything which he would not do or omit if he were not so deceived. And number 3 ಅಲ್ಲಿ one first, ಮತ್ತೆ two ಅಲ್ಲಿ A and B, ಮತ್ತೆ three. In cases covered by 2B ಅಲ್ಲಿ, the act of omission should be one which causes or is likely to cause damage or harm to the person induced in body, mind, reputation or property. Full stop, property. Hence, it is clear that to establish the offense, of cheating, the complaint is required to show that the accused had fraudulent or dishonest intention at the time of making any promise or misrepresentation. Making or representation, full stop. In the case on hand, there is no such a fraudulent or dishonest intention. Intention is forthcoming while perusal of the evidence of PW4, full stop. PW4. Though the prosecution has relied the evidence of PW7, 8 and 9, all these witnesses have deposed that after the incident, a panchayat was held to pacify the row between the accused and deceased, accused and the victim family, full stop, victim family. As such, their evidence no way helpful to the prosecution case to prove the guilt of the accused, full stop. As far as the charge under section 324, 324 of IPC, the prosecution has not placed any such documents, any such medical records,
323, sir.
323,
Yes, ma'am.
any such medical records, or the evidence of the doctor, full stop. Doctor of the evidence of the doctor. Further, to bring home the guilt of the to bring home the guilt for the offense under section 3 subclause 2 to 5 this of the provisions of SC/ST Act, the prosecution is required to prove that the accused should have committed the offense against the member of the scheduled caste, knowing that she was the member of the scheduled caste. Knowing that she was the member of scheduled caste, full stop. In the evidence of PW4, there is no such evidence of she has not, nowhere it is stated that the accused was aware about her caste before caste, while they both were loving each other, full stop, loving each other. As a matter of fact, the PW4 admitted that she used to visit the house of accused frequently, and they both visited. They both used to travel. They both used to travel together once in a or twice in a week. In such circumstance, the offense under the provisions of SC/ST Act also does not attract in this case. Full stop. In this case, admittedly, the victim was, the prosecutor was aged about 25 years. So also there is a inordinate delay of 20 days in lodging complaint, and the evidence of the doctor who treated the injured victim also Also not observed any such injuries or the possibility of sexual act committed by the accused in such circumstance, the learned session judge, in such circumstance, we are of the considered view that the learned session judge
My
has
lords.
rightly
Page number 33, para 9, what she has stated in her evidence, she due to
Okay.
she inflicted injury on herself, that is improvement that has also come. Yes.
In such circumstance, I'll mail on that 324 prosecution has not
323.
323 on the prosecution not placed in medical evidence full shop. Per contra, otherwise, per contra, the prosecution in her evidence, in the evidence of PW4, she herself admitted that
Yes, ma'am.
she admitted that she herself
Frustrated and took the blade and inflicted injury
The blade and inflicted injuries.
on her left wrist.
So inflicted injury, and so those injuries are inflicted by herself, self-inflicted, and those injuries are self-inflicted. One line analysis in the circumstance, we are of the view that the learned session judges rightly appreciated the evidence on record, and passed the reasoned judgment, which does not call for any interference. Full stop. Moreover, this appeal is against an acquittal order, one judgment is acquittal order, judgment, acquittal. The Honorable Apex Court summarized the law, the interference, law in respect of the interference of the appellate court in a case of acquittal. In a case of acquittal, in a case of acquittal, that is it's Sundar versus state. Sundar versus state of next one Mallappa. Extract month. Extract month. According by placing reliance on the above judgments, placing reliance on the guidelines issued by the Honorable Apex Court in the above judgment, we proceed to pass the following. We answer the point raised above in the negative and proceed to pass the following. Appeal, criminal appeal, for the state is dismissed being devoid of merits.
My lords, tomorrow's criminal appeal.
Tomorrow, Tuesday, 3 appeals. Six three I thought Monday, serial number 21. I take up serial number 21.
21. On Monday, my lords.
ಅದರಲ್ಲಿ ಒಂದು ಸ್ಟೇಟ್ ಅಪೀಲ್, ಒಂದು ಅಕ್ಯೂಸ್ಡ್ ಅಪೀಲ್ ಇದೆ. ಟ್ವೆಂಟಿ-1 ಮತ್ತು 21.2 ಅಲ್ವಾ? ಇದು ಎರಡು ಅಪೀಲ್ ಯಾವುದು? ಸ್ಟೇಟ್ ಅಪೀಲ್ ಯಾವುದು? 21 ತಗೊಳ್ಳೋಣ.
Yes, on Monday.
Monday ಅಲ್ಲ, Tuesday. 21. 2 appeals are there, na?
Yes.
Nandakishore ಮತ್ತೊಂದು ಮಾಂತೇಶ್. So 2 appeals ಇದನ್ನ ತಗೊಳ್ಳೋಣ. serial number 21.
Please.
ಒಂದು ವೇಳೆ ಅವ್ರು ಬರೋದಿದ್ರೆ ಇದಕ್ಕೆ ರೆಡಿ ಆಗಿ 23ಗೆ serial number 23. 23 ಅಲ್ಲ, 25. 23 ರೆಫರೆನ್ಸ್ ಇದೆ. 25.
Yes.
State appeal.
Yes.
So 25 ಮತ್ತು 21 ರೆಡಿ ಆಗಿ.
Yes.
21 and 25 ready.
Please,
Tuesday.
please.
The time is there.
No, there is no opposite side. Tomorrow the
Opposite side. Opposite everywhere.